I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt.
Due to allegations that he put off his tether and contacted the complaint. Following that particular bond hearing, I instructed my client to not contact the complainant witness, period, in the jail.
Put up their money. They did that. Your parents are down here with all their time and everything, trying to stand up for you, and you did this.
Before I already made the mistakes, Your Honor. It was way before that. I thought I got put in there for 30.
Here's the problem. You've interfered with the whole system. That's the problem. You should have never done any of this. We don't do that either. Defendant's bond is revoked. Defendant's remanded. I'll see him on the 13th, and counsel, you can give me your argument as to what I should do with the bond at that point. But right now, he's remanded.
Thank you, Judge. I also instructed my client that if allowed to be back on the bond, we would ask the court to hopefully reinstate his original bond. Tether, we know, Judge, that he has no prior criminal, well, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Now, obviously, people address this. Some of the language that was used during conversations, I don't have phone conversations myself, but I will admit, Judge, that it seems that my client had contact complainant even after his bond. And so I say this, Judge, and again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. He is.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something, it means it. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier bond that he did opposed to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So Judge, I am asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. And so at the very least, the restriction on his phone privileges to contact family.
All right. Well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, you know, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on our motion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim with other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if you're particularly, you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but it's close, but I did pretty good. I said it okay right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. You're worried about my child. I can't say that I'm not in here for nothing. You obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. Can't please show mercy. Please.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir. Is all discovery complete?
And I would ask if possible, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge Perry.
And Your Honor, I did want to make it clear where I did contact the jail yesterday, and they have blocked both of victims' new numbers and old numbers, so there should not be any more
calls coming through. All right.
Your Honor, as I explained at the bench, people are seeking an adjournment. Quite a few things have come up. The evening with the, and I mentioned is that the officer in charge is at 4 p.m. this morning that he's ill, cannot be here to testify. We would need his testimony here today. Your Honor, there was also the issue of the jail calls that were made. This defendant, while he was in custody, called the victim multiple times. The content of those calls are highly concerning to the people. They suggest witness tampering. The fact that she is not here today kind of completes the concern we had that his calls and his communication with her have had the effect that he intended them to have. Specifically, we have concerns because he gave her a story of what to come and tell the prosecutor's office. She did comply with that, and as counsel is aware, and courts know where she has indicated to us what I would call a recantation, but certainly a different version of events matching what this defendant instructed her to do. There's a lot more to it, including statements he made, telling people that the victim was not coming forward and so on. With all that, Your Honor, we have concerns, so we need to further look into that. Those calls were shared with the public defenders already. I resent the very specific call to defense counsel this morning. I'm going to be listening to those a little more closely. I'm considering witness tampering charges moving forward. And we do have concerns about this defendant being out of custody and the behavior he might have engaged in and may continue to engage in, and making sure that the victim does not appear to testify against.
Extraordinary.
With respect to the people's adjournment request, at this time, we have no objection to that.
Okay.
And I had an opportunity to speak with my client, Mr. Larry, and Mr. Larry Sr., who is present in court today. Miss Larry was here earlier, and both of his parents really have been calling off work, making every effort to be all of their son's court dates. I
recall that the last time he was here, they were here. I recall that. Okay.
And in addition to that, I know back on April 27th, Miss Larry wrote a character letter to the court, which I know the court can't consider at this juncture. However, that was sent to counsel, and I reviewed that, and Miss Larry speaks highly of her son. And I think, you know, insofar as Mr. Larry's at a fork in the road, they are committed to make sure he takes the right path and comes out of this continuing the positive work he was doing before arrest in this case. And I would note that this is Mr. Larry's first interaction with the criminal justice system, as far as I can see on his criminal history. When he was released from custody after spending about 30 days in jail, he was placed on home confinement and lives at home with both of his parents. During the time he was in custody, you know, he had to deal with the consequences of being in custody, which included losing his job. His parents want him to get a new job, and I talked to Mr. Larry about essentially scheduling an interview, talking to his tether agent, and seeing if there can be an accommodation made for him to go and do an interview, which I know, you know, if that needs to be done by stipulation or order, I know it's something that has been accommodated in the past. Mr. Larry's enrolling in school. He's Washtenaw County Community College for either CDL or HVAC licensure, but he's trying to get higher education. And I think since he's been out on home confinement, he's certainly not been violating the court's orders.
Well, but the problem is, I don't know that. That's my great difficulty.
When I talked to Mr. Larry's parents, I was very specific about what the court's orders are, including no contact and what no contact means. They ensured me that they're not going to let it happen under their roof. And as far as he's on home confinement, I mean, what they relayed to me is essentially the court's home confinement tether at this point is he'd be on home confinement anyway. They're making sure that he's staying on the right path. They don't want him to end up in jail or, you know, at the end of this case to be worse off than he was coming into it. So I'm going to ask the court respectfully to consider continuing his bond at this time. Come back on the next date. I've already talked to Ms. Tana about resolving this case. I'm going to talk to my client at length about resolving this case, which, you know, what we pondered does entail further court supervision. But as far as abiding by the court's orders, you know, Mr. Larry and his parents are going to make sure that continues on.
My difficulty is that I believe that his parents have all the best intentions of the world and are probably the most disappointed by all of this. But I myself am very disappointed when I find as I told you, counsel at the bench, I gave him a huge break the last time in letting him out, knowing that there were phone calls. That's come back in certain respects to bite me because I now know that these weren't just, not to minimize them necessarily, but not just context to the alleged victim saying whatever. He was to manipulate the system. I don't even know what's going through his head. Well, he should be, because he's got me right now. He should be scared. Because the grand reality of it is that I can't trust you to be out. I don't know what you're doing. Understand what I have here. I let you out. I gave you the opportunity. You create some story that the no. No, because you want to believe in him. That's fine. I want to believe in him too. I gave him an opportunity and he has messed this up and is now facing potentially another felon. And I don't know that you even understand that, young man. No, you don't. Why would you put yourself in a position to pick up another felon? You weren't even supposed to be communicating with this person at all. But then you communicate and you go even further to concoct some story and now and here's what you have to understand from that. From that, you concoct that story and then I have no victim here today. She not only takes the story that you give her, communicates it to authorities, then doesn't show. Go ahead if you think it's advisable to say something to me, because I am livid right now.
Takes me on the phone with them. Oh, she agreed. She tell me how.
Your Honor, I would ask the court to consider the fact, since Mr. Larry's been released on home confinement, I think almost right away, he got into some level of domestic violence programming. I spoke with Ms. Tana. There's a program that we are both familiar with that I want to refer him to immediately. And into addressing, the underlying allegations here, it addresses those of issues in terms of it was a bond violation trying to impact the outcome of proceedings, those kinds of things. And I want to make sure that, Mr. Larry's getting to the resources he needs. I think if he's at home on home confinement with his parents, I think he's in a better.
How do I know he's not contacting the victim?
Well, when I spoke to his parents, Your Honor, they advised.
I don't doubt that they're going to do the best they can. I trust them. I don't trust him.
Mr. Warren Green, what kind of choices is available in jail if he wants to start that? Might be advised.
Your Honor, my client would just assure the court he's not going to violate any court orders, including the no contact
He
order.
assured the magistrate of that after his arraignment.
I was nervous and she was pregnant, so this is my first time, Your Honor.
What?
Your Honor, I think my client's expressing that it is his first interaction with the justice system. He was nervous about the ultimate outcome of this case. It's a big.
What confusion do you have of do not contact this person?
I don't think it's confusion, Your Honor. He admits to violating the court's orders with respect to the no contact order. I think it's naivety, and I think it's him trying to change the outcome of this case. I understand that as far as it's a bond violation. I'm not sure if it rises to a matter where we're dealing with forfeiture by wrongdoing at this point. So I don't want to go too far down that road in terms of what I address, but he knows that's a possibility at this point. And at this point, we're kind of shifting gears and talking to the people about a resolution that involves significant domestic violence programming.
And for the record, if I may, at least 38 calls were made to the victim using other inmates' pins. So being naive, that to me doesn't indicate a naive person. That is deliberately working to kind of fight the system, trying to get out of it. And I agree, trying to affect the outcome of this case. And that's exactly what we're trying to prevent.
And see, it's that behavior why I can't trust you.
Staying here.
Because I don't have a doubt your parents are going to put everything they can possibly put in place to try to make sure you don't mess this whole thing up. But we do the same thing in the jail by giving you a PIN number. And what do? You try to circumvent and go around that whole thing. Then you try to concoct some story, and that comes back. And now you're going to potentially face another felony, as well as proceed without the victim on this case. You don't even begin to understand what the heck you've done. And if you had just stuck by the rules, we wouldn't even be in this boat. I don't need to have this conversation with you. I don't need to try to make sure that the victim in this case can proceed with this case if that's what she so chooses to do.
Okay. 30 days. That I did. It's already, mistakes were already made. Myself, 30 days.
Your Honor, I'd ask the court to consider that the time Mr. Larry spent in custody did have an impact on him. And moving forward, if the court is gracious enough to consider continuing his bond at this point, he's going to comply with any of the court's orders, but that's going to be a constant reminder as to what happens when he does not. And, you know, I referenced naivety earlier. He didn't think he was going to get caught, and he did. And I think he knows at this point, and his parents well know at this point, if he's caught in violation of his bond conditions whatsoever, he's on thin ice, and it's going to land him back in jail. If it does,
I don't know if he cares, Mr. Warren. I really don't know if he cares. Because if he had cared, he would not have done what he did.
he's been working on himself a lot. This arrest, hopefully, in the long run, going to be the biggest turning point in his life. And that's his sentiment he's expressed to me this whole time. He's got two people that really care about him, that are really going to make sure that he stays on the right track if the court's gracious enough to continue his bond at this point.
The bond that was posted for you was not your money, was it?
No, sir.
It was your parents' money.
My brother and my sister.
Then you got your family here. Everybody's trying to do everything for you except you. Here's what the problem is, counsel. I've got to figure out, and I've got to give the people time to figure out why this victim isn't here. But until such time, I mean, do you know how long it may take people to figure out if they're going to bring additional charges against him?
Your Honor, I have no problem reviewing it today. I do need the OIC to do some. So I would ask for a week.
I'll adjourn the preliminary exam matter to May 26, 2026, 9 a.m. before me. That's in person. At this point in time, man, you got to understand, you make your bed, you got to lie in. I'm not going to, don't look at me like this is you. Your family put up their money. They did that. Your parents are down here with all their time and everything, trying to stand up for you. And you did this.
Before, I already made the mistakes, Your Honor. It was way before that. I thought I got put in there for 30 days.
Here's the problem. You've interfered with the whole system. That's the problem. You should have never done any of this. So if the people would do that, review it, get in touch with counsel, but this time I'm going to revoke his bond. Defendant's remanded. I will consider his release if the people can figure out exactly where they're going to go with this and have the OIC. I'd ask them to hurry up and do it. I don't want to leave him in jail, but he's made his bed and that's where he is now. But I got to figure out that everybody else in this whole system is safe, not just you. Dad, don't do it.